All right, guys, welcome to the legal steps in foster care. And we are in part 2. And tonight we have Megan back with us again. And so I'm going to go ahead and turn it over to Megan so she can get started because we want to use up every minute we have, Megan. I'm sure we'll have questions.
For those of you who weren't able to tune into part 1 of the series, I know Gail had reposted that in the Facebook group. So some of this stuff has already been talked about as far as foster care, kind of from the initial call to DSS through termination of parental rights. And as Gail mentioned, I'm Megan Spidell Beaver. I practice family law in Greensboro. I own my own family law firm, and I do a lot of DSS juvenile type work. And so one of the things that we had talked about at the very end of the last presentation in February was termination of parental rights. And I know that we kind of were crunched for time there at the end. And so in speaking with Gail, she wanted to do a little bit of a recap of that, just because that is one of the big questions that you guys have. I have gone through the Facebook group and kind of searched certain key terms to see what people are asking and what people want to know. And so tonight we're going to talk a little bit about the recap of termination of parental rights and appeals, and then also what options there are for permanency planning, as far as custody, kinship and guardianship, TPR and adoption, and all of that tonight. And if you hear my dogs, I apologize. It is pouring down rain and they will not go out. So first off, with the termination of parental rights, kind of like I said, the recap, the goal is that when the parents have demonstrated that they will not be able to provide the degree of care which promotes the health and orderly physical and emotional well-being of the juvenile, it is necessary for the juvenile to have the earliest degree of care and at the earliest possible age, while at the same time recognizing the need to protect the juveniles from unnecessary severance of the relationship with the biological parents. So once a court is moving towards ceasing reunification, and a lot of times you'll hear that called the change of plan, at that point you're moving forward with one of the other options, and a lot of times that's going to be termination of parental rights. Once the actual change of plan order is entered, the TPR is supposed to be filed within 60 days. And I will go ahead and tell you that I know you are commenting that these deadlines are not being followed. Gail, correct me if I'm wrong, but if someone is having specific issues with that, email Gail.
Yes.
She is working on it. We know that COVID got things delayed, but the change of plan order is supposed to be entered 30 days from the court date when the judge says it out loud. And then from that date, when the order is entered, the TPR is supposed to be filed within 60 days. So if that's not happening in your counties, let Gail know, because we are aware that that is an issue in a lot of places. So once the TPR is filed, the hearing is supposed to occur within 90 days. That is not happening. And the court basically says, unless there's good cause shown for the delay, and that's a lot of different reasons, COVID being one of them, delays and backlogs and other cases being one of them. If you've had a case pending with the court since 2018, then that case is going to take priority over a case that was filed in 2021 in pretty much every county. Sometimes they'll let uncontested ones jump ahead. If there are long contested ones that are going to take a long time, they'll let those uncontested ones get done quickly. But a lot of times the delay is just because we've gotten behind. And so that's part of the issue. Once the TPR is filed, the court is looking for two things, and it's essentially what we call a bifurcated hearing. The first thing they're looking at is, are there grounds to terminate parental rights? And the grounds are found in our statute 7B-1111. And so the grounds are these: the parent has abused or neglected the juvenile, and that a lot of times that's already going to have been found in your DSS case. The parent has willfully left the juvenile in foster care or placement outside of the home for more than 12 months without showing the to the satisfaction of the court that reasonable progress under the circumstances have been made, correcting the conditions that led to the removal of the juvenile. So that right there, those two things are normally going to be handled in your DSS case. You're going to probably have a finding of abuse or neglect, and you're going to probably have 12 months where a parent has not successfully worked their plan and shown the court that they're going to work their plan. Just a little side note, no parental rights can be terminated for the sole reason that a parent is unable to provide care for the child because of a poverty issue. The juvenile, third reason, the juvenile has been placed in the custody of DSS, a licensed child placing agency or foster home, and the parent for a continuous period of 6 months has willfully failed to pay a reasonable portion of the cost of care for the juvenile, even though they're physically and financially able to do so. So a lot of times when DSS takes custody, they're also going to be simultaneously filing a child support action against the parent, so that if the parent does fail to pay child support or pay for the cost of care during that time in foster care or in kinship placement or wherever they may be, then during that time, that's going to basically satisfy the third requirement there. Another reason, and I do a lot of these private TPRs, is when one parent has been awarded custody of the juvenile by a court order or by agreement, and the other parent has failed for more than a year to pay for the care, support, and education as required by the order. So basically, this is where there's a custody order granting one parent custody, and the other parent's supposed to be paying child support, and they're not paying pursuant to their court order for more than a year. The next reason, the father of a juvenile born out of wedlock has not, prior to the petition being filed, either established paternity one of the following ways: either filed an affidavit of paternity, legitimated the juvenile by marrying the mother of the child, providing substantial financial support and consistent care with respect to the juvenile or mother, or established paternity through paternity testing. So if they have not done any of those things, then again, that is a ground for TPR. That the parent is incapable of providing for the proper care and supervision of the juvenile, such that the juvenile is a dependent juvenile, and that there is a reasonable probability that the incapability will continue for the foreseeable future. And it goes further to say that this may be a result of substance abuse, intellectual disability, mental illness, organic brain syndrome, or another cause or condition that renders the parent unable or unavailable to parent the juvenile, and the parent lacks an appropriate alternative child care arrangement. So that second part is essentially that not only are they unable to provide care for the child, but they also are not able to name anybody else that they could name as an alternative arrangement. I haven't looked at the actual statistics on this, but based on what I'm seeing, my guess would be that there is a large increase under this particular provision, and it'll normally accompany some of the others like neglect, but because of substance abuse and mental illness increases, I think this one we're going to see a big change since COVID. The one that I found most in private cases is number 7. The parent has willfully abandoned the juvenile for at least 6 months, next preceding the filing of the petition, or if it's an infant, voluntarily abandon the infant for at least 60 days right before the filing of the motion, so or petition. And I'm going to just text someone to tell them to let my dogs out because they're driving me crazy. Okay.
And we can't hear them, Megan.
Okay, because they're really loud in here.
No, you can't. We can't hear them.
Okay. The next one is the parent has committed murder. This should kind of be a no-brainer, or voluntary manslaughter of another child of the parent or another child residing in the home, or they have aided, abetted, attempted, conspired, or solicited to commit murder or voluntary manslaughter of the child or another child of the parent or another child residing in the home. Basically, if someone's killing the parent of the child or another child in the home or a sibling of the child, then that's going to be grounds. The ninth reason, the parental rights of the parent with respect to another child of that parent have already been terminated involuntarily by the court, and the parent lacks the ability or willingness to establish a safe home. So if there's been prior TPRs, I know there's somebody that said, I think that there's been 6 prior TPRs and that their case is on its way to TPR. That in and of itself is one of the reasons for TPR. And then where the juvenile has relinquished to a county department of social services or licensing or child placing agency for the purpose of adoption or placed with a prospective adoptive parent, the consent or relinquishment to adoption by the parent has become irrevocable. That is a reason as well. So if you place the child for adoption, then that satisfies one of the requirements as long as the time to revoke that consent has expired. And then the last one is the parent has been convicted of a sexually related offense that resulted in the conception of a juvenile. So if that is a rape situation and the child was conceived, you can terminate the parent. It's important to know that you only have to prove one of these. When they're coming from DSS, they're typically going to have abuse and neglect. They're going to have failure to make progress on your case plan for more than 12 months. You're likely going to have a failure to pay child support. So you're probably going to have a combination of these on your TPR if they're a DSS case. But if they're a private TPR, then sometimes you don't have as many. So that's step one. So once the court finds that there are grounds, then you move to the best interest. So when I say it's a bifurcated trial, if the court says you guys didn't show that there's grounds here, and so we can't move to step 2, then the case stops there. If the court says yes, there's grounds, then you move to the best interest. And again, it's important to note that you only have to prove one of those grounds, but just proving the grounds doesn't mean that the court will necessarily find that it's in the best interest of the child to terminate. So the best interest factors are found in 7B 1110 in our statutes. And the things that the court considers are the age of the juvenile, the likelihood of adoption, whether the termination of parental rights will aid in the accomplishment of the permanent plan for the juvenile, and we're going to talk about all the permanent plans later, the bond between the juvenile and the parent, the quality of the relationship between the juvenile and the proposed adoptive parent, custodian, guardian, or other permanent placement, and then any other relevant consideration. This could be criminal activity, drug abuse, all kinds of other things that the court could consider when determining what is in the best interest of the child or children with termination of parental rights. So once the court has found both of those things, then the rights are going to be terminated. They're no longer going to be a party to the DSS case. And even if the other parent is still involved with DSS, they can still terminate one of the parents. And then the termination of parental rights orders, and I'm seeing a lot of comments on this on the Facebook page as well, are supposed to be entered within 30 days of when the judge orally gives the ruling. And those orders are completely and permanently severing all rights and obligations of the parent to the child and the child to the parent. With one exception, until the child's adopted, the child can still inherit from that parent. So if that parent dies and they have $1 million estate and that child has not been adopted yet, they can still get their $1 million or however much would be allotted to them until they're actually adopted. And then you are going to be having post TPR reviews. So within 6 months of that TPR order being entered, and then every 6 months thereafter, until permanency is obtained, the court is going to want a status update on what efforts have been made to get this child into a permanent placement, whether that's adoption, guardianship, custody, and we're going to talk about all of those here in just a minute. A lot of people have also been commenting about the appeals process. And so once the TPR order is entered, parents do have the opportunity to appeal. They've got 30 days, and if they miss that deadline, there's not really any mulligans on that. They don't get to come back and say at day 42 that they're going to appeal it, because the court's not going to hear it. They do have to meet that deadline, and that is one thing that the Court of Appeals is going to say, you've got to make that deadline. TPRs are the most commonly civil appealed case. And when you think about it, if they are severing a constitutionally protected right. It is the most severe thing you can do in the civil realm. In the criminal realm, obviously, imprisonment is the most severe thing. But they are very commonly appealed. If a parent had a court-appointed attorney previously, they're likely going to qualify for a parent defender at the appeal level as well. The Court of Appeals are currently being held by a panel of judges at the North Carolina Court of Appeals in Raleigh. There was a brief period of time when they were actually being sent straight up to the Supreme Court. That didn't really work out. So now they're back to the Court of Appeals. So you're going to have a panel of judges that is reviewing the underlying case. The appeals are taking anywhere from a year to 18 months. And that is statewide. So a lot of you were saying, oh, appeals are taking less time in our counties. That is not going to be accurate, because they're all going to the same place in Raleigh. Now, some panels may be moving faster as far as which judges are assigned, but they should all be going to the same place and determined by the same type of people. So once they file the appeal, if that parent attorney thinks that there's no grounds for the appeal, then they're going to file what's called a no merit brief, which means their appeal had no grounds to be appealed, and that's likely going to go much faster. If they determine that there is grounds for the appeal, that there was something improperly done, some evidence that shouldn't have come in that did, or some evidence that did come in that shouldn't have been, then I'm going to do the same thing twice. If I did, just, it's been a long day. Then you're going to have those deadlines that I showed last time, and Gail's going to email those out as soon as I email them to Gail. But so there's going to be briefs due. These are not court cases where you're going to get to go retry your entire case. Typically, TPRs are just going to be appealed based on the briefs alone. So what the attorneys are submitting, these long briefs on what the issue is for appeal, why it is an issue, why the court should review it. And then they're going to come back and say, yes, the court made the right decision. They're going to say, no, the court made a completely wrong decision, and reverse it. Or they're going to do a middle ground of, the court needs to make different finding of facts or additional findings of facts for this to pass the Court of Appeals scrutiny. So that's kind of TPR in a nutshell. I'm going to try to answer these questions as we go. So one thing Gail said, if the timelines are not being met, please email her. She has put that into the chat box. Incarceration. If a parent is incarcerated, that in and of itself is not grounds for TPR. Parents can still maintain a relationship with their children if they're in jail. Now, if they're incarcerated for murdering another child in the home, murdering the child's parent, rape of the parent that produced the juvenile, that's different. Those are all grounds in and of themselves. But just being incarcerated is not enough for a TPR, because you can have phone calls from jail. You can send letters from jail. I had somebody who was making art and sending it from jail. You can send money from jail. If you get a job and you don't spend it all on the commissary on Twix bars, then you can be sending support back to your kid from jail. So even if a parent's incarcerated, that doesn't necessarily mean that they have given up all rights to their child. Somebody said, yes, first degree murder, the sibling was just released after being in jail 7 months. Again, just being in jail in and of itself is not going to be enough for incarceration itself. If they were trying to reach out and work their case plan from inside the jail cell, then probably not. But if they murdered a sibling, then that's going to be a different situation. both parents are TPR together. So they can be TPR'd separately. It depends on if one parent's working the case plan and the ultimate reunification goal is there with one parent and not the other. It's common that they're going to try to see if the other parent is going to work their case plan, even if the other one's going to be TPR'd. So it doesn't have to be both at the same time. And then what happens if they can't find the parent? So North Carolina allows service by publication. So if you don't know where the parent is, and this is going to be very common with unknown dads, even if you don't know who the dad is, you still have to serve unknown fathers. And the way that this gets served is through publication. So it's either in the newspaper in the city where the known person last lived, or if you don't know any of that, then you publish in the county where the child was born, and you're going to typically use the child's initials, and it's kind of in not so proper terms, basically anyone who's been with this mother in the 10 lunar months prior to this child being born at this hospital on this date, come forward and tell us that you're the dad. And if nobody comes forward, then they can terminate an unknown parent. Why wouldn't this as a parent and children keep contact? So I think what you're asking, are you asking if somebody's in jail? If they're in jail, DSS can't force them to make the calls. DSS can't force them to send the letters. Whether they allow visitation, that's a separate issue, but contact, and yes, COVID has played a big piece in this, because any visitation that was previously allowed got pretty much cut off in the jails. And even transportation to and from, like termination of parental rights trials, some of them have had to do it via Zoom and things like that, because COVID, they wouldn't transport them between jails for the hearings because of the influx of COVID cases. So, but yes, if they're in jail, it's not DSS's role to hold their hand and make them contact. If they have phone privileges and they lose them for bad behavior, or they trade their phone privileges for money for the Twix bars at the commissary, like, it's not DSS's job to make them work their case plan. So it's no different than if they were on the outside. Publication is 3 consecutive weeks, and I was seeing all kinds of time frames across the board. It is 3 consecutive weeks for any civil case in North Carolina. So whether your DSS worker or your GAL or whoever's talking to you is telling you it's 45 days or it's 60 days, it could be because by the time that it runs 21 days and you get the notice back and you're able to get a court date, it could be 45 or 60 days. Or it could be that it's taking that long for the newspaper to send the documentation back, but it only has to run in the newspaper for 3 consecutive weeks. So I am going to move on to what the options are for a permanent plan. Obviously, the #1 goal is reunification, and we're kind of talking about, if reunification is off the table, what are the next options? And so I'm going to talk to you first about kinship generally, because kinship, and a lot of you may have kinship placements, is when the child is placed in the home of the child's relative or in the home of an adult with whom the child or the child's parent already has an emotional tie. And so this doesn't necessarily have to be a family member. DSS typically prefers that it be a family member, but it can be a close family friend. It can be somebody who was raised, like my sister, but isn't really my sister. So that's kinship placement as far as when they're still in, DSS custody. And then once the reunification efforts have ceased, kinship placement can split off to custody, guardianship, or adoption. So I'm going to talk to you first about custody. Looking for a minute. So custody generally is the same under the statute, under 7B11. After a child has been adjudicated and adjudication and disposition have both occurred, then the court can transfer jurisdiction to a Chapter 50 case, which is our general Chapter 50 custody case. It's like a normal mom and dad custody case. And so after disposition, and so the child's been found to be neglected, abused, or abandoned, or dependent, then they're going to be able to terminate juvenile court jurisdiction and move on to Chapter 50. So they're moving it out of DSS court. That means that DSS is no longer involved. They're no longer going to be supervising things. They're not going to be working case plans, that this other person is now going to have custody. And this is not permanent. So it's permanent, but later, if the parents wanted to file a motion to modify custody and they could show the court substantial material change of circumstances, they may be able to get back in. So although these are all labeled as permanent plan, quite frankly, the only one that's totally permanent is adoption. So custody happens kind of one of two ways. If you already had an underlying custody order, like a mom and dad, and now DSS is involved, then whoever is getting custody is going to have to probably intervene into that case to become a party before anything else can happen. And then you're going to have to show that the parents have, anytime it's a third party, so a non-parent, not mom, not dad, then you have to show that the parents have either neglected the welfare of the child, are unfit, or have acted in a way that is inconsistent with their parents' constitutionally protected rights as a parent. Again, DSS has kind of already done this for you by adjudicating them abused, neglected, or dependent. So you're going to have some of that already. But if there's already a custody order between mom and dad, there's also going to have to be a motion to modify custody, and you're going to have to join that new party. No, custody is not the same as guardianship. So this is an actual custody order, similar to if my husband and I got divorced and we were fighting over custody. It would be in that courtroom. It's not in the juvenile courtroom. It's not the same process at all. But it is one of the permanent plan options. So the next thing I'm going to talk about is kinship. And Gail, feel free to jump in whenever you want. Again, this is when reunification efforts have been determined to be contrary to the health, safety, or best interest of the child. The county has determined that reunification is no longer an option for the child. Legal guardianship is another option. And again, kinship can transfer into legal guardianship as well. Again, it's a way to find the child a permanent remedy, but there are some ways. For example, if a parent comes back and says, so if I'm the child's guardian and a parent files a motion to modify that guardianship and says that I have done things that I'm unfit and I'm acting against the best interest of these children, then the court could modify that later. Now, that doesn't automatically mean that it gets modified to the parent, but it could mean that the modification or the guardianship could actually get modified. You get varying levels of responsibilities under guardianships, because one thing I will say, a lot of times guardianship means that there's still visitation with the parents. It allows them to have a permanent residency with a permanent, and again, I'm using permanent, it's permanent, but it potentially could be modified. Means that person is taking on the legal rights and responsibilities with regard to the child, but it also means that the parents are likely still going to have visitation. And I've seen a lot of people going back and forth on Facebook, kind of in a little bit of a debate on why guardianship is good or bad. Guardianship does not sever the relationship between the parents. Guardianship does not change the birth certificate. Guardianship does not allow you to change the last name of the child like adoption does. You can get guardianship and later file a termination of parental rights and later get adoption. So there are still options to do those things later, but the kind of point of the guardianship, the point of guardianship is that the parents' rights are not terminated in that situation. Later they can be, but when you initially enter into it, that's not really the goal. Do you have anything else to say, Gail, on just the guardianship issue?
And
There's
I'm
some comments
speaking
about visitation and financial. I don't know if you want to address the financial now before we move on.
Yeah, we can. And I'm speaking from a personal case that I have, that a child is in guardianship. And so I am not an attorney. I'm not giving legal advice when I speak here. So the big thing to understand is that it usually comes up when there's a situation where adoption cannot be secured. And maybe one parent we can TPR, but the other one we couldn't. Or the case has been going on so long, it's in the best interest of the child to go to guardianship and then later down the road to TPR. And that was basically the scenario that I was in. And so the visits, it's something that's negotiable between the attorneys and the county, and then when the judge then makes the order. And it's basically something that you can come up with on your own. And so our visits are done virtually. It is not in the best interest of the child to have face-to-face contact, so virtual visits. And that was, something that we landed on. The how frequently, once a month. It could be something as simple as that, all the way to weekly visits. And I always get asked the question, who supervises those visits? Guess who has to do that, guys?
The guardian.
The guardian. And now you can go through the visitation centers that are across the state, and you can, if you don't feel comfortable, you can go through that route. And we have parents that are doing that currently. The big thing, and I do want to share one thing with you guys, and let me share it real quick because it is an amazing resource. And I literally spent a lot of time on it today just so I could share it. And my email is going to pop up for just a second. Did the guardianship pop up?
Yeah.
Okay. So the guardianship versus adoption and the differences and all that, it's laid out on our website because this is the number one question that I get. I get the phone calls and the emails. And so we've laid it out here. You're acting as a substitute parent, just how you've been doing. And we go all the way through. You take on the financial means. However, I want you guys to go down here where it says learn more here about the financial support. And I'm going to click that. And it pops up to work first. So if you have a child that's in guardianship or custody, reach out to work first, because what that let me be eligible for is the child can get a stipend every month. The child's still eligible for Medicaid if that was not negotiated when you did guardianship. The child can also get, are you ready? This one's a big one. You can also get daycare assistance. So
Gail,
you're
can you click see more right
I'm
there?
sorry?
Click see more so everybody can see the rest of that paragraph.
Oh, I'm sorry. So the other thing is, by giving you adoption assist, daycare assistance, that will allow you to continue working if you're a full-time employee. And the time frame that's on here, that's stated here, this doesn't apply to guardianship cases that we're working through as, previous foster parents and such. And so I made sure to call the Raleigh Office of Work First. They talked me through it. One of the questions a parent asked me was, what if I take the stipend and I take the Medicaid, but I don't need the daycare vouchers? You can pick and choose which program within Work First. You do not have to take the whole program. And that was something that a parent had been told. So when you begin going through that, if you get told some information about you have to take the whole thing, that is incorrect. And this is eligible up until 18 years of age for the child. And so I have people that say guardianship may be even better because you could have access to daycare and things like that, whereas in adoption that stops. And so that's one benefit of guardianship. The other thing is the guardianship, and this was huge for my case, is that the child is considered sorry, I'm trying to jump back. The child is considered a party of one, a family of one. So your income does not count for any of that program. Your incomes don't count. And that was changing for us big time because my child has a disability that's under guardianship. And so I was able to then go apply for disability for my child, and he received the disability because my income didn't count. He's a party of one. And so that for me was life-changing, because that right there, just allowed him to so many more services. And that's how you're eligible for that Work First, is the child is considered a party of one or family of one. So I hope that helps clear up the guardianship and takes the fear out of it. Yes, Work First can be accessed through custody cases, but the key there is they look at how you are related to the child. So if you take guardianship of a child, and this is the only caveat about the party of one, and you are kin to the child, then that child goes under your income.
And when you say kin, you're not talking about kinship as far as you don't have to be family. You're talking about actual, you have to be family.
Yes, you have to be family, and it has to be, and it's actually, when you start getting generations out, they're like, well, you're not really kin, or if somebody marries in versus actual kin and things like that. So it is one of those situations where you're gonna have to call Work First for your case and work through it. And if you're not getting the answers you need, feel free to email me. We can go back and look up everything, and then going into deeper things. TPR is dragging on. Timeline for guardianship is, I found out 2 weeks. We were on TPR track. We were going for TPR. In 2 weeks time frame, my case went from, I'm going to have at least 2 to 3 more years in the system because of an appeal, because of all that, to guardianship was granted in 2 weeks, and I was done. Now, some cases get called back in. They may set it up to review it, say in 6 months or a year, but in our case, it was one and done.
And I have a case on this week for trial where guardians, because of a lot of reasons, have filed for termination of parental rights. So they have guardianship, they're filing for TPR, and then the child's going to be available for adoption. So,
and Megan, will you answer Debbie's question?
Where's Debbie? No, if they are 18, and I'm going to get to adoption in just a second, and I do want to reserve as much time for adoption because I know that a lot of people have questions, but you do not have the TPR of the child if they're the parent, if they're adults.
And the child care comes in the form of a voucher, Wendy, and also the stipend. It's nowhere near what the foster care payment is, or what you would get an adoption stipend, but it is some. And
I think it's along the lines of like a third.
You're exactly right. You're exactly right.
So just on the guardianship, things to remember, you're going to have the responsibility to essentially act as the parent of the children. You're no longer having to necessarily co-parent, but there are things that the parents may still be involved in. It really just depends on how the guardianship is worded. It's not relinquishing the rights of the parents. So there may be rights that the parents are reserving to still be involved in. They are typically going to still have to help financially support the children. They're likely going to have visitation, but that visitation can look like Gail was saying, it could look like regular phone calls and the ability to see them once a week. It could look like Zoom visits. It could look like once a month. It just really depends on how it's worded. And there's a lot of different options. And again, the parents can try to modify that if the person is unable to care for the children or unfit. And so all of that, and there is less financial support available. So all of that is guardianship.
Megan, can I segue into adoption for you?
Sure.
So 6 months of zero contact, 6 months of no financial payment in. Guess where I'm headed? I'm going for a private TPR. And so make sure, and here's something else I learned just a couple of weeks ago. Even though a court retains jurisdiction, when you go to file that TPR, you have to file in the county where the child resides. So mine was from another part of the state, 3 hours away, and now I'll have to file where I live in Asheville. So just keep that in mind.
I just learned something new.
Yeah.
I thought if the court had jurisdiction.
That wasn't legal advice. I learned it.
So private TPR is when you're not going through DSS. You're not waiting on them to do it. You're going to hire your own attorney. That attorney is going to file the termination of parental rights for you. If there's a DSS active case, then you are going to, and I think that's the difference, is that your guardianship was done, and if you're actively in a DSS case, then you're going to have to file in that county. I don't know if certain counties are going to frown upon this, trying to file it outside of DSS, but DSS is going to have jurisdiction, so you're going to have to file it in the same county where your DSS case is pending. So, and I know, did we want to talk about kin gap really quick?
Yes, please.
So the kin gap is a kinship care and guardianship assistance program. And again, the criteria for that is that the court has determined that reunification and adoption are not appropriate permanency plans, that the child has been in a licensed foster home for a minimum of 6 months prior to the guardianship being awarded, that the youth is in the placement responsibility of the County Department of Social Services at the time of the guardianship entry into kin gap, and kin gap literally stands for Kinship Guardianship Assistant Program. That the youth is at least 14 years of age, but not older than 18. So this is for the kids that are falling in that 14 to 18 age range, that adoption's not going to be possible or not the permanent plan, and that they're going to go the guardianship route. Or they're the sibling of a qualified youth who is also placed in a guardianship arrangement. So they don't necessarily have to fall in there if they are the sibling of a child that falls in that range. The youth demonstrates a strong attachment to the prospective guardian and has been consulted regarding the guardianship arrangement. And then the prospective legal guardian shall have entered into the guardianship agreement with the county who holds custody of the youth prior to the order granting legal guardianship. So they've entered into this kin gap agreement prior to the guardianship order being entered. The child falls in that 14 to 18 age range. And that is going to allow a couple things. It's going to allow monthly cash assistance at a standard monthly board rates beginning the month following the establishment of the guardianship, and it continues until the child turns 18. If they enter into the guardianship assistant at age 16 or 17, then those benefits actually can continue to age 21, as long as one of the requirements, as long as they meet one of the requirements for foster care, age 18 to 21. And then Medicaid is also available. So all of those things are in the kin gap. So big ticket item. I'm going to spend the rest of my time talking about adoption. Kind of a little known fact, under Chapter 48, adults may adopt one another. Any adult can adopt as long as they meet all the requirements. They have to be 18. You've got to pass a background check, fingerprinting, pre-placement home studies. So the question about the 18 to 21-year-old, you can adopt that person. And you'll see that a lot with step parents, where a stepfather has raised the child and dad's been out of the picture, but for some reason he either won't consent to the adoption, or they can't find him, or they get him served and he contests the TPR and you can't get him TPR'd. You'll see children that, eventually want to be adopted by that step parent. They'll wait till they're 18 to do it. Who can be adopted? Any living individual can be adopted. Prior to same-sex marriage being allowed, you would see a lot of this happen where one partner would adopt the other in order to protect inheritance rights, because North Carolina didn't recognize, and a lot of states didn't recognize same-sex marriage. And so the couples would adopt one another, or one would adopt the other, to protect inheritance, because the property distribution laws in North Carolina and the probate laws in North Carolina didn't apply. It's also commonly used for older stepchildren who are adopted by step parents. I already said that. I do a lot of step parent adoptions. These are very common when a parent remarries and that step parent wants to adopt. You do have to have either a consent to adopt by the biological parent or a termination of parental rights. And if the child is over age 12, and this applies across the board, your child has to consent to being adopted. And so a lot of the cases that we're talking about with guardianship, maybe they are proper for guardianship and maybe the court would like for them adopted, but you have a 13-year-old saying, no, I'm not being adopted. I love my parents. I don't want to be adopted. So if you have that situation, and teenagers are going to be teenagers, then they do have to consent if they're over the age of 12. Adoptions can happen through DHHS, they can have, or Department of Social Services, they can happen through agencies. Under kind of the types of adoptions, you can have a direct placement where a birth parent is agreeing to place the child with you for adoption. Again, it's still going to require consent. It's still gonna, you're still gonna have to meet all of the statutory requirements as far as background checks, etc. And you're still gonna have to have that pre-placement assessment. Agency adoptions, that's coming directly from an agency where the agency is working as the go-between between the bio parents and the adoptive parents. For the purpose of this, agency is also DSS. They're that middleman. And then there's international adoptions, which are a whole different conversation for a different day. And if you're fostering here in North Carolina, you're probably not looking at international adoptions, but just a small caveat, if you adopt in another country, you have to re-adopt them once they get to the United States, which is a whole complicated mess. So who has to consent to adoption? The bio mother, and it must be after the birth. If they have relinquished for adoption and the time has to revoke has passed, then that's good. Any man who may or may not be the minor child's father, and that is a really weird way to say that. If there's been an adjudication that the man is not the father, then he does not have to consent. But this is not just a paternity test saying you are not the father. This is an actual adjudication from the court that says you are legally not the father. If a man wasn't married to the mom and they signed a denial of paternity, if they've relinquished the child for adoption and the time to revoke that has passed, or if the parent is not yet 18, they can still consent to adoption. So any man that may be the child's father has to consent to the adoption. That's an interesting way to put that. But then those other things that I just read out are the exceptions to that. If there's an adoption agency involved, they have to consent. If there's a guardian of the child, then they would have to consent if it's not the person adopting. If the child is over 12, the child has to consent. If there's a guardian ad litem for an incompetent parent, that person has to consent. If you're adopting through DSS, the child is likely going to have already gone through the TPR process, so they're already going to be legally free for adoption. So you're not going to have to get these consents. You're not, aside from the child, because you've already gone through all of those steps. Consent is obviously not required if the parent is dead or if the parent has been convicted under the rape statutes. The effect of the consent once it's entered is essentially that legal and physical custody is being transferred. That does not relinquish or TPR the parent, but it does, once a parent signs that consent form for adoption, they're essentially saying you now have legal custody of this child. Consents can be revoked up to 7 days. If the home study has not yet been complete, then that time is actually extended until after the home study comes back plus 5 days. And a parent can revoke their consent within those 7 days, and they can later reconsent. And if they try to revoke the second consent, it's irrevocable. They can't do that. Let's see. I'm just looking at my notes here. Okay, so the process for the adoption. When you file a petition for adoption, the prospective adoptive parent is the person filing. And at this point, the child is likely already going to be living with you. The contents of the petition or of the adoption packet are going to be the petition, certified copies of any custody orders, certified copies of any termination of parental rights orders, any affidavit of parentage where a dad has signed off saying that they're dad, any relinquishments or consents to adopt by the parents, certified copies of the health and social history of the minor children. If you have to have ICPC approval, so interstate compact for the placement of children for out-of-state adoptions, and then any consents for the agencies also have to be done. Once you've filed everything with the court, then it's normally going to be a 90-day waiting period. There are some waivers of that, but they're kind of sparsely granted. And then after that 90 days, but before 6 months, that adoption is going to be granted. So you're probably looking at a 90-day wait period unless there's some reason that you're going to qualify for a waiver. If somebody contests it, so if you file for adoption and you notify the people that are supposed to be notified and they contest it, so like a parent, then if it's contested, it is transferred from the clerk, where they're normally granted, to the district court for a judge. And the court has to show that all of the statutory requirements that we've talked about have been met and that the adoption is in the best interest. If for some reason the consent form that mom signed was voided because she signed it under duress, then that is one of the reasons that it could be set aside. This is important for moms who have had C-sections, because some people will have them immediately sign the consents, but if you're under a bunch of pain meds, then you probably need to wait until those have worn off. So a lot of practitioners will say don't have anybody sign it until 48 hours after they've given birth if they've had a C-section, just to ensure that they're of clear mind and that they're like making a sound decision. Do we ask for adoption after TPR? So if you're going through an agency, the agency is likely to help you with the adoption. Gail, if they're foster parents after the TPR, DSS is not going to help with that, correct? Or are they?
No, I mean, are you asking in a guardianship situation?
Somebody
Karen?
said, do we as foster parents file for adoption after the TPR, or does DSS do it?
DSS is going to walk you through the process, and you actually get reimbursed financially for the attorney that comes along beside to do the case. And so some DSSs, some counties allow you to pick someone. Some of them already have it prearranged with who they use. I just got that question this week from a parent. So, and then you have to work through your adoption worker at DSS to see how the route they're going to go. But it all comes out in the end the same way. It's just a matter of, do you actually hire the attorney, or do they point you in the direction of attorney and help you walk through it? Does that make sense?
And if you're licensed through an agency, they're normally already paired up with attorneys that they're going to have you work with. So you wouldn't be, if you're a foster parent through an agency versus DSS, you're going to have somebody probably already assigned to you.
Correct.
So as far as the timing or the effects on the adoption, it establishes a legal parent-child relationship between the child and the adoptive parents. And that makes them entitled to inherit from you. It gives you the exact same rights as your biological children. And then it severs any remaining relationship between the biological parent and the child. Although I will say a parent would still owe child support arrears if they had past due child support. It allows you to change the birth certificate. Point here that biological grandparents could still come in and request visitation, and that's something that a lot of people don't know. If somebody wants to appeal it, it has to be filed within 10 days with the clerk. Your birth certificate, once the clerk files your adoption, and it's going to be sent off to Vital Records in Raleigh, the new birth certificate is going to be printed. This part just totally blows my mind. They erase the original parents and they put on the new parents. And I always tell this story because it's fun. My grandma was adopted by her stepfather when she was like on the cusp of 17, 18. The age difference between my great grandmother and my, I guess, step grandfather was pretty large. My great grandmother was a lot older. So now my grandmother's birth certificate looks like her dad was 13 when she was born, and that her mom was like in her 20s. So it's really interesting. So they actually replace it. So, you know, regardless of who was on it before, they're removed. And now you have a brand new birth certificate that shows the child's new name, the child's date of birth, where the child was born, and to those two new parents or one new parent. So that's always interesting to me. Step parent adoptions are another thing that I do commonly. And that requires that the step parent and the bio parent actually legally be married at least 6 months. They have to have a marriage commitment. Step parent do have to get a home study if you've been married 2 years or less. You're going to have all the consents, the TPRs, the relinquishments. You're going to have the consent of the child, and that's still going to be the 90-day waiting period, unless, again, there's some reason for the waiver. One of the things that the foster parents' rights established was that if your case moves to adoption, the foster parents are to be considered for adoption. And I don't know how much kickback people are getting from that. But I know that there have been some complaints about that. And you also are required to be given notice and opportunity to be heard at the adoption process, especially if you've not been selected as the adoptive parent. So that's something important to remember, that your foster parents' Bill of Rights does do that. Once the adoption papers are signed and goes to a committee, you get your large papers are filed through the court. How long is the time? Okay, so it's 90 days. So somewhere between the 90 days and 6 months range. One thing I will say, a lot of you were posting about your like adoption ceremonies and your court date. I do a lot of these in Guilford County. We have no such thing. They go to the clerk processes everything. Sometimes we know when they're coming down the line, sometimes we don't. Sometimes we'll say, hey, we should have this finalized on this day. So, you know, the planning of the party and all of that, if you're doing an adoption party, it may not happen exactly like you think. A lot of the counties are processing them with the clerk, and they don't ever have a real court date, and you don't ever go before a judge. So sometimes you can arrange for that if through your social worker, if you want to have your, you know, courthouse photo taken with the judge. But on these adoptions, a judge is not signing them, it's the clerk. So they don't have a courtroom. They just do this in their office. So any final questions? We have 1 minute.
I just wanted to throw in here about the post-adoption support. When you follow the link that I put in the chat, all children adopted in North Carolina, whether adopted internationally, privately, or through DSS foster care, they're eligible for post-adoption services. So click on there and you can get an agency. They're super trained and, you know, use them. Notice that the regions they have listed there are not the regions that we're moving to with the 7 in North Carolina. So one last question, Megan, that's on there.
So under the statute, it doesn't actually specify why they're supposed to be waived. It specifically just says that at least 90 days have elapsed since the filing of the petition for adoption, unless the court for cause waives this requirement. And that's why I'm saying that there is very rarely is that 90-day period going to be waived. And it looks like you said that yours was less than 30 days from when you signed the petition. So I do not know, but good for you. Don't know why that would happen so quickly.
There's been a couple recently that have gone through that quick.
And I just know a lot of our counties, or at least the counties that I practice in, are not going to waive that. They're going to make you wait 90 days. So if you have a smaller county that has less to process, they may be more willing to do the waiver.
All right, so we're finishing up since we don't have any final questions. Here is the evaluation that I'm dropping into the link. I've got to open it up for everyone to be able to sign, so don't click on it yet and give me just a second to fix that. If there are no other questions, or if you have questions and you didn't ask tonight, just make sure you can send it to me. And it's just info@ffa-nc.org. And we'll go from there. Give me just 1 second to open up the evaluations. I'll leave the webinar on so you can follow that. And I hope you have a good evening, and we will see you next time.
Thanks, everybody. Have a good night.
Thank you, Megan, as always. Give me 1 second, guys. I'm trying to go fast. And this is so you can get your link. All right, go ahead and try now and see if it's working. Vicky, that would be an attorney question, so I'm not sure about that one. And again, here's the link for the evaluation. Excellent. Thanks, Lindsay, for letting me know. And that way I can send you guys the evaluation. I'll leave this up for those that need to grab the evaluation link.